Mr. Donovan, I believe you are here on behalf of the appellant. Is that correct?
Yes, Your Honor.
And did you wish to reserve any time for rebuttal?
Yes, 5 minutes, Your Honor.
Thank you, counsel. Okay, we are ready to proceed. You may begin.
May it please the court. I am Attorney Sean Donovan. I represent the appellant and husband in this matter, Antoine Morcos. This is a case where a trial court granted a domestic violence injunction regarding an incident where the wife had been arrested for domestic violence and then awarded the exclusive use and possession of the marital home to the wife, despite the fact that she had not lived in that residence for the last 2 years. There are 3 questions presented, namely whether a domestic violence injunction may be granted solely based upon the past history of violence and without a finding that petitioner is in imminent danger of becoming the victim of domestic violence, whether a court, by repeatedly referring to evidence not admitted at trial, rebuts the presumption that it did not consider such inappropriate evidence prior to making its ruling, and whether a court in a domestic violence injunction matter can award petitioner exclusive use and possession of a home that was neither a dwelling that the parties shared nor the residence of the petitioner. As to the first issue, the prior acts of violence alleged by the wife are too remote in time to be the sole basis for a domestic violence injunction. In this matter, in the return hearing, the wife put on 4 witnesses in her case in chief, namely the husband, who refuted all allegations of violence, and her 2 sisters and herself. The 2 sisters testified exclusively about allegations of violence that had occurred when the parties were residing together at least 2 years prior. While their testimony was devoid of specific facts, it was general allegations. Both sisters did confirm that the allegations did occur while the parties were residing together in the marital home.
And didn't the trial court confirm that it was considering that information to the extent that it informed a decision as to whether her fear of violence was reasonable? Isn't history of violence reasonable for that determination? Or
Judge, the court did not make that specific finding. There was...
Well, it's not a specific finding. It's just an explanation. Here are the factors. Isn't this relevant to, one of the things that I need to consider in determining whether it's a reasonable fear of future violence?
Well, Mr. Morcos feels that the court should have stated that it did not. The wife testified about not only acts of violence that were alleged to have occurred more than 2 years prior, but also current allegations stemming from April 12th, which was the day of her arrest. On April 12th, there was a child exchange where the wife brought the minor children to the former marital home where the husband was residing. And at that time, she forced her way into the home. She was under a recording, and it was shown that she struck the husband and called him an expletive. In her petition for dissolution of marriage, she made statements that did not comport with that video, that were very different, stating that the husband was the aggressor. The wife called law enforcement. She called 911 on April 12th. Law enforcement arrived, and the wife informed the deputy that she had a bloody finger but had no other injuries. And she stated that she did not know how she got the bloody finger, but alleged that her husband had pushed her out of the home. The petitioner's fear of imminent danger must be objectively reasonable, as is cited in the Mitchell v. Mitchell case at 198 Southern 3rd, 1096, which is a Florida 4th DCA case from 2016. In this case, the trial court said the court must consider the current allegations of the parties, the behavior within the relationships, and the history of the relationship as a whole. The wife's only allegations of current violence are contained in her description of the April 12th incident, which again was caught on video. Notwithstanding that, the timing of of her filing the petition for injunction is very telling. She filed the petition for the domestic violence injunction after she was released from jail for having battered the husband.
Mr. Donovan, I'd like to address your third argument, which I think may be your best one, having to do with the trial court's jurisdiction to award exclusive possession of the home in this procedural context in this case. I get your argument that the statute says in a domestic violence injunction, the trial court can award exclusive possession of a dwelling that's shared by the parties. And the question I have for you is the term sharing the dwelling in the domestic violence statute to be interpreted so narrowly that the statute doesn't apply to authorize a court to award exclusive possession in the circumstance where the petitioning spouse vacated the home because of violence and still has ownership rights in the home, paying the mortgage, and has personal property in the home?
Well, Judge, notwithstanding the fact that Mr. Morcos disputes the fact that there was violence caught driving the wife out of the home, any allegations of that violence fall back to the remoteness in time, because it was those allegations.
I think you're misunderstanding my question. My question is how to construe the text in the domestic violence statute. We know that there's a parallel proceeding and dissolution underway. And ultimately, is it sort of a default, the possession of the marital home that's where that will be adjudicated. And at this point, your position, and it's plausible, right? That this is not the marital home. It is a marital asset that needs to be addressed in the dissolution proceeding. But given the domestic violence statute, which says that the court has authority to award this in the injunction if it makes the findings, and let's assume for purposes of my question that the findings concerning the violence are sufficient, I'm having trouble determining whether we should interpret the statute so narrowly that the only time a trial judge can award possession of the home is if the parties are living in it on the day of the events that constitute, the last events that gave rise to the petition for protection.
Well, Judge, I would say yes. That is the plain language of the statute. Notwithstanding the fact that the wife, at best, latches would apply. She waited 2 years to bring this to the court's attention. So I think the spirit of the statute is to allow someone who is a victim of domestic violence, who is currently in danger of being battered and has nowhere else to go, give them that safe haven of being able to stay where they are.
We know she had somewhere else to go because she'd been living with her parents down the street for 2 years.
Yes, Judge. So she has been living there for 2 years. She had another residence.
So you're saying that conversely, the legislature's intent is to reward the spouse who managed to drive the other spouse out of the house in fear by letting the spouse who is able to stay continue to stay in the house. I mean, wouldn't that be the flip side? I mean, based on your position, isn't that what the legislature would be allowing?
Well, Judge, it would. The difference, the distinction between that question and what the actuality is here is that there was such a great distance of time between the allegation of abuse that drove her out of the home.
So how long does she have to? Because you said to Judge LaBritte that she had to be living in the home right up until the last the incident of violence giving rise to the petition. So now you're talking about there's a period of time. So what's the period of time?
Sure. The plain reading of the statute is it has to be a current residence or
doesn't it just say they have to share the residence?
It has to be they have to share the residence or
so not current, just share. Okay,
yes,
go on.
share the residence, or that to remove the respondent to allow the petitioner to reside there. So if the question is, what about how long does it have to be? How long can someone wait? It would fall back to the issue of the remoteness in time. And
See, I don't see anything in the statute about time. It comes down to what does share mean? And share doesn't necessarily have a time component to it.
Sure.
What you're talking about is share means physical presence. There's no temporal component to it. And so what qualities constitute sharing?
Well, for the purposes of this statute, the husband would argue that share means that they share that as their residence. It's a shared.
If that's the case, wouldn't the legislature use the word occupy?
It may have, it may. They selected to use the word shared.
I mean, could share mean that they both remain title owners and financially responsible on a collaborative basis, which seems to have been the case here?
That is the case here. However, if shared could have that level of a flexibility, it could be applied to someone who owns a rental unit and it wants to take over the area that's being rented by a tenant. If there's an injunction.
I'm wondering if the legislature used the term share to be a broader word than occupy, sharing the residents' living, sharing responsibility for, sharing the maintenance of it, because if this may be a fact before a dissolution proceeding or something, they may wish to preserve the asset. The legislature may have reasons why they use the word share to be a broader term than merely occupancy, and using share to include occupancy and other responsibilities. I don't know, I'm not in the legislature, but I'm just wondering that the word occupy comes to mind pretty quickly, and share seems to be a word choice that they would have used to connotate perhaps more than occupy.
Yes, Judge.
I don't know if I'm right. I mean, that's the argument that we get to bounce back with you and forth and your opposing counsel on this one.
Yes, Judge. It is the appellant's position that shared under this statute means living together in that household. But I concede it is up to interpretation and it could be ambiguous. Next, the trial court's finding.
Just so you know, you're at 12, so you can now pace yourself with regard to the rest of your argument.
Thank
so you
you
know what time you have left.
Thank you, Judge. The trial court's findings rebutted the presumption that the court had disregarded inadmissible evidence and improper evidence at the trial. The court, in making its ruling, acknowledged the fact that the wife had attempted to introduce evidence that was improperly submitted, which was timely objected to by the appellant. However, at the end, the court stated, so I've heard a whole lot of different things today, and my guess is that there's a whole lot more that has gone on and that I've probably heard about today. This is a bad situation. It's not a good situation. In the midst of it all, you folks are going to have to raise 2 children together without domestic violence. So I'm finding that Ms. Gadd has met her burden of proving that a history of domestic violence and that she's been a victim of domestic violence. That statement in and of itself is referring to evidence that the judge did not have access to, but was attempted to be brought in front of him. And therefore, it would rebut the presumption that the court did not include that in determining that the injunction should be granted. Based on the foregoing, Mr. Marcos would ask this court to find that the prior acts of violence alleged are too remote in time, that the wife failed to prove objectively a reasonable fear of imminent danger, and that the trial court's findings rebutted the presumption that the trial court had disregarded any inadmissible evidence in making its ruling, and that the court inappropriately awarded the wife exclusive use of possession of the former marital home. And therefore, we would ask that you reverse the ruling of the trial court.
Thank you, counsel. Attorney Dodge, you may respond. You need to unmute, please. You are muted. Whoops, now you're gone.
Sorry, it told
Welcome
me
back.
spacebar. My apologies. It told
No,
me
don't be. You,
spacebar.
you work your technology about as well as I do, so I'm with you. I'm very
you, Your
sympathetic.
Honors.
You may go ahead.
Thank you very much. Good morning, Your Honors, and if it may please the court, I'm Attorney Lisa Ann Dodds, and I'm here today on behalf of Miss Angie Gadd, lower court petitioner and the appellee in this matter. I would like to start off by saying I think that all three of Your Honors hit the nail on the head when you were addressing the house issue. And how the house issue overflows into all of the other issues. We know as attorneys that the law is not black and white. We make our living in the gray, and there's no more gray area in the law than family law. This is a very sad case. The facts of this case and the evidence that was adduced at trial absolutely supports the finding that an injunction was necessary. In reading through the facts of the case and in reading through the transcript, the petitioner very clearly had been a victim of domestic violence. She went into detail about being sexually accosted, unwanted, being the victim of sexual advances, not just while herself and the respondent were cohabitating together, but when she had stepped away from the residence by force, and she would still have to communicate with the respondent. He had made sexual advances towards her. He had told her that she was his property. All of these things manifested themselves in such a fear that at one point, Miss Gadd even goes into detail about being in such fear that she urinated on herself while he had her pressed up against the car. So these are very sad facts, and it is what it is. These things occurred, and there are two young children that are now living with their mother at the mother's parents' house down the street in a living room. So the court properly took into consideration the best interests of the children when they were talking about awarding a marital home. And to go back to your point about what the case law has to say about whether or not it's the mutual home or whether it's shared or whether it's occupied, I believe Honor Yukum hit the nail on the head. This is not meant to be a reward for somebody that bullied the other party out of the home.
So Ms. Dodds, help us
Yes,
out. In scouring the cases in your brief, I wasn't able to find one that directly paralleled this one.
Okay.
I think there's a line of cases that you briefed. Coleman is probably the principal case. And I think that case is distinguishable in the jurisdictional piece having to do with awarding possession of the house, because in that case, neither party had qualified for relief under the domestic violence statute. And therefore, the possession of the home, the marital home, had to be determined in the dissolution action. You're effectively arguing the other side of that. And the point your opponent makes, and I think the fulcrum of this analysis is your client moved out 2 years ago. And there is a parallel proceeding in the dissolution case that ultimately will finally resolve the possession of the marital home. And one concern is, did your client do an end run around the dissolution court? But more directly, the text of the statute, and you heard us talk about this with your opponent, allows the court to award exclusive possession of a dwelling that the parties share. But the concern here is they haven't shared the dwelling from the perspective of occupying it together for over 2 years. And your opponent makes the point that, and I'm not sure where this is in the record, but I can be educated, that there's potentially a latches issue with regard to your client's delay in bringing this matter to the court's attention, or maybe the dissolution court's attention. Can you address all of that?
Yes, absolutely, Your Honor. Thank you. And that's a very good point. And your analysis of the way that I stated it in the Coleman case in my briefs is absolutely correct. I was arguing the opposite. because had the trial court had jurisdiction and under issuance of the injunction, then they would have also had the jurisdiction to award exclusive use of the home. And how that parallels to the dissolution case. The dissolution case had been filed a year and 4 months prior. I want to say it was I wasn't counsel originally on the dissolution, but I want to say it was filed a year and 4 months prior to the injunction being filed. Absolutely nothing had been done on the dissolution case. And as counsel on the dissolution case, I can tell you we're still at a standstill. My client was not trying to do an in and around to get exclusive use of the marital home. She had been trying to get it in the dissolution matter. And unfortunately, she was bullied out of her home. And when she's bullied out of her home and she has 2 young kids and she's staying in a living room at her parents' house, she has a right to request it in the domestic violence petition, which she did.
So your interpretation squares with Judge Rothstein-Newcomb's question, which is the legislature didn't intend, and this text of the statute doesn't support, an interpretation that the respondent can effectively be rewarded for bullying the spouse out of the home.
Yes, Your Honor, that's absolutely our position. And it's further evidenced by the fact that my client did keep belongings there the best that she could. She would go there to retrieve the children's belongings and their things so that there could be a co-parenting or shared parenting in the best interest of the kids. And
direct us to the record, the specific, give us an insight if you could, to the part about your client continuing to pay the mortgage on.
Off the top of my head, Your Honor, I will have to flip through and find that, but I know that there's.
Don't waste your time.
Oh, yeah. So I do know that there is a portion when Ms. Gadd was on the stand and it was inquired upon her why she believed that she was entitled to continue to go into this marital home. And she said, well, I continue to pay the mortgage. It's still my home. My things are there. Something to that effect.
Wasn't there evidence that her sister made some or all of the down payment on this house?
Yes, Your Honor, that was a statement they kind of misunderstood. That's more going towards the dissolution. However, when the home was originally purchased, the sister, absolutely, you're right, the sister did give a gift of a substantially part of the down payment to Angie, Ms. Gadd, so that she could purchase the home. So yes, your recollection is absolutely correct. And being that she had 2 young children, was paying the mortgage, there was no other alternative, no other place for her to live. And to circle back to how it all intertwines with one another, the reason that in my opinion, the reason that the trial court decided as it did is when it looked at all of the evidence and all of the statements that were adduced at trial. It was obviously a bad situation. It was a bad living situation between the 2 parties, and the wife or Ms. Gadd cannot be penalized for leaving to try to protect her children from acts of domestic violence or witnessing them. When we talk about the events that gave rise to the filing of the petition, April 12th, that happened during a child exchange. If Ms. Gadd is attempting to do what's best for her children, i.e. continuing to have contact with their father, but keeping separate and apart so that the parents can cooperate together, then she's doing what is in the best interest of the children and what is in the best interest between the parties. So I wanted to touch on what happened on April 12th, the events that counsel had spoke about. The wife, as he put it, that was arrested, Ms. Gadd, she was arrested, and it did say in the report that the officer had testified that there was no opportunity for Ms. Gadd to give a written statement. There was no opportunity for Ms. Gadd to give an oral statement. And subsequent to the arrest and being released, the arrest, no matter how you cut it, the arrest is an act of violence. So if the act of violence that opposing counsel is talking about being too remote in time. Well, it can't be remote in time if it's coupled with a recent occurrence. The recent occurrence would be the April 12th violence. And subsequent to the arrest on the April 12th date, the state dismissed all the charges. They no-prossed the case because they believed the same as the trial court did, that this was a one-sided presentation of events that occurred on April 12th. Furthermore, Ms. Gadd's two sisters had witnessed the acts of domestic violence that they testified to directly, including being strangled while breastfeeding, including having multiple things thrown at them, being hit, pushed, and kicked on several occasions. And Ms. Gadd's testimony of being beaten on multiple occasions and having her head smashed into walls. The reason I think all of this stuff is relevant is because the judge, of course, as the trier of fact, is sitting there listening to how these individuals are saying this, listening to the quiver in their voice, listening to the details of their firsthand accounts. And the judge was able to also take into consideration the cultural diversity in the backgrounds of these two parties, which I also think is important. Both husband and wife are from Egypt. So when they came to this country, these acts of violence were common. These acts of violence were normal. The wife is viewed to be property. And in reading the appellant's brief, what the appellant is asking you to do is to actually go back and reweigh the facts and to say, well, she didn't bring it up for X amount of time. She moved out of the home and didn't ask for it back. She filed this injunction out of retaliation. Appellant is asking you to go back and reweigh the facts. And those facts have already been weighed and they were deemed credible in the appellee's favor. So are there any questions?
Doesn't appear so at this moment.
Well, then I would go ahead and conclude by saying it's very obvious that the appellee met a prima facie case to support the issuance of the injunction. The court made this decision, albeit a very difficult decision due to the high amount of emotion that surrounds circumstances like this. The judge made a decision and he gave an overall view of the case, which is very, very common in family law. And based on all of this information, the court correctly decided that an injunction for protection against domestic violence was in fact necessary. So it's for all these reasons that we ask the court that the entry of the trial court's injunction for protection for domestic violence be affirmed.
Thank you, Attorney Dodds. Attorney Donovan, you may rebut. I'm glad. Thank you for unmuting. You have your 5 minutes, counsel.
Thank you, Judge. The appellee would have the court believe, based on the facts, that she was living in great fear and that had endured years of abuse. The appellee would have the court find that just because the appellant comes from Egypt, that he is an abuser.
I don't mean to interject too much, but I remember when I read the transcript, did I miss where it said they came from Egypt? Was that in our transcript? Did I miss that? You may know, but I was wondering, I didn't remember reading that, but that doesn't mean I read it and forgot it. So
I don't believe it's in the transcript. It was just in the appellee's oral argument.
okay, thank you.
Yes, Judge. But all of that is belied by the video that was introduced into evidence by the husband.
But Mr. Donovan, let me stop you right there, because the trial court has made that credibility determination. The trial court was presented with her testimony, was presented with the video. It's the province of the trial court to make the credibility determination. And we absolutely cannot second guess that here.
Yes,
so
Judge.
that ship has sailed.
Yes, Judge.
So, so based on the trial court's credibility determination, you need to tell us why reversal is warranted, but we can't go behind that.
Yes, Judge. Based on the argument that has been made on behalf of the appellant here today, he does request that Your Honors reverse the trial court's ruling. And at that point, we will rest.
Thank you, counsel. Thank you both. I guess at this point, they transfer you back over, or you transfer yourselves back over to wherever the so-called waiting room is. Don't ask me any more than that, because you have the limit of my skill set. So thank you. Stay well.
Thank you very much, Your Honors.
And we'll move on to the fourth case this